All right, we're on the record. This is in regard to the motion this morning to either allow or deny admission of Mr. Hall's question and answer statement given on an earlier occasion. I've had a chance to review the transcript of that as well as case law. And first of all, denying the defense motion to have the prosecution give an offer of proof or an explanation for why they are not granting immunity. I think even as the super case cited by the defense notes, immunity, the grant of immunity is strictly an executive branch function. It's not really subject to judicial review. And so regardless of what the state's reason was for refusing to give immunity to Mr. Hall, it's not reviewable by this court. So the request that the state provide a reason for not granting use immunity is denied. With regard to the statement given by Mr. Hall, and this assumes that he is not going to be answering any questions even if I order him to do so, I'm going to find that none of the statements in the question and answer statement are admissible. First of all, in Johnson versus Fabian, that noted the basic standard for a Fifth Amendment claim and how broad it is, and it tends to be much broader than 804b3. Under the Fifth Amendment, answers that would in themselves support a conviction or that would furnish a link in the chain of evidence needed to prosecute the claimant are incriminating for purposes of the privilege. And in fact, in discussing that, that was from Johnson versus Fabian, which is 735 Northwest 2nd, 295, which was cited by the state. They also note that the privilege allows an individual to refuse to answer official questions put to him in any other proceeding, civil or criminal, formal or informal, where the answers might incriminate him in future criminal proceedings. That standard is obviously fairly broad. And so if it might incriminate the defendant or provide a link to other evidence that might incriminate, the invocation of the Fifth Amendment privilege is appropriate. In contrast, 804b3 states, in part, pertinent part states, a statement which was at the time of its making so far tended to subject the declarant to civil or criminal liability that a reasonable person in the declarant's position would not have made the statement unless believing it to be true. In other words, if somebody goes into the police department and confesses to a murder, generally people don't do that because, unless it's true, because it so clearly tends to subject the declarant to criminal liability. And that is judged from the time of the statement's making. And the statements that are contained in the question and answer statement are in fact not the type that would clearly be so far contrary to the declarant's penal interest or subject that person to criminal liability that they would not make them unless true. Most importantly, for example, Mr. Hill totally denies providing controlled substances to George Floyd. He talks about how he was appearing tired and all that, but the entire statement seems to be Mr. Hall describing what does not incriminate him. He's willing to do that, but when it comes to anything that he might have done, he denies engaging in any activity like dealing. There are some sporadic references to dealing on the street, but there's nothing specific as to time, date, location, persons involved, that the person would be subjecting themselves clearly to criminal liability. Accordingly, it does not fall under 804b3. Under 807, a statement not specifically covered by Rule 803 or 804 may be admitted, but it must have equivalent circumstantial guarantees of trustworthiness. I see nothing internally within the question and answer statement that Mr. Hall's statements had any guarantees of trustworthiness, and accordingly it is not admissible under the rule for that reason. The defense does have a right to a complete defense, but since there are witnesses who can testify as to what, and have testified as what Mr. Floyd looked like at the time. I don't think that the rules of evidence must give way completely to any claim of this evidence is necessary for a complete defense. I find it is not, and accordingly it is not admissible. Any questions about that ruling from the state or from the defense? All right. We have other housekeeping things, but we'll handle those after the jury. Unless you wanted to take care of some of those now, we can do that after, because we're going to be done before 4 o'clock. Is that correct? All right. Why don't we deal with the housekeeping things and that afterwards? All right. We'll be in recess until the jury's ready. Maybe we can get them out maybe in 5 minutes. Will your witnesses be available? All right. Let's look at reconvening in 5 minutes.